All right, it is 4 p.m., which means it's time for the Washington History Seminar. Welcome to all of you. Welcome to the Wilson Center. Welcome to this session on fraud in American history from Barnum to Madoff. My co-chair, Eric Arneson from George Washington University, will shortly introduce our featured speaker today. Let me just do the preliminaries and say thank you all for joining us here today. This seminar is a collaborative effort with the National History Center, an initiative of the American Historical Association. We, as always, like to acknowledge the very generous support by the Society of Historians of American Foreign Relations for this series, as well as GW's History Department and a number of anonymous donors that support this effort. As always, I like to appeal to all of you to join the ranks of those donors, anonymous or not. This series doesn't organize itself, and so we are always looking for new resources. Both of us would like to thank Amanda Perry from the National History Center. Amanda, right there, raise your hand. You're really one of the organizing forces behind this seminar that gets us organized, as well as Pete Bierstecker all the way in the back there, who is on my team here at the Wilson Center. I mentioned the collaboration with the National History Center. I think that's all that I have, except to remind everyone that next Monday is President's Day and the Wilson Center is closed, so we don't have a session next Monday, but then we reconvene on the 27th for Timothy Breen from Northwestern University on an appeal to heaven. And a final reminder to please silence your cell phones so we don't get interrupted in what I think promises to be a very, very interesting, intriguing talk. So,
it's my pleasure this afternoon to introduce our speaker, Ed J. Balleisen, who braved the very windy skies that are buffeting the nation's capital to come to us from North Carolina this morning. Ed Balleisen is Vice Provost for Interdisciplinary Studies and Associate Professor of History and Public Policy at Duke University. His most recent book is Fraud, An American History from Barnum to Madoff, published this year by Princeton University Press, and it is available for purchase and presumably signing after this session. The book is right outside these doors. Other volumes of his include Navigating Failure, Bankruptcy and Commercial Society in Antebellum America, which appeared in 2001, a co-edited volume, Government and Markets Toward a New Theory of Regulation, that came out in 2009, and a 3-volume research collection on business regulation that appeared in 2015. He has won 3 teaching prizes at Duke University and is a leader in the national conversation on refiguring doctoral education in the humanities. And today, he will be speaking on the subject of his new book, Fraud, An American History from Barnum to Madoff. Ed.
Well, thank you so much for that warm welcome. I've always felt that there's a great potential for exchange between historians and policymakers, as well as other protagonists in the policy process. And I see the National History Center as a really important vehicle for that type of exchange, so I'm really delighted to be here today. So let's get started. The premise of the research that resulted in this book is that fraud is endemic to modern capitalism. That's the point of this poem from 1873. It's no less true as you read it. It's no less true if you're talking about 1823 or 1923 or 1973 or right now. I suspect that everyone in this room has encountered business fraud not too distant in the past, and I don't just mean reading about it in the papers, then that's a weekly experience. I mean being the target of a telemarketing scam, or having your elderly parent be the target of such a scam, or realizing that you've taken a hit in your retirement fund because of a corporate accounting scandal. Fraud in any modern capitalist society is just a key element of the terrain. And it makes for really compelling individual episodes, and as a result, it makes for compelling micro-histories. Fraud episodes tend to produce really fascinating characters. These episodes have really dramatic plot lines. And as a result, we have many excellent case studies of fraud, biographies of people like Charles Ponzi or Samuel Insull, books that engage with specific episodes like the Florida real estate scandals of the 1920s. Journalists at the moment are penning many, many books about frauds, business frauds in more recent years. The premise of my book, though, is that there are really significant comparative advantages of macro history, of being willing to step back and take a look at not just the details of the lives of a huckster like P.T. Barnum or the trajectory of a specific investment fraud like those at Madoff Securities, but rather to take a step back and think about broader dynamics over a longer time frame. One big advantage of this longer view, I would argue, of looking at the longer arc, is that you see something that historians tend not to emphasize that much, and that's continuity. Historians, for good reason, are focused on change over time, and I'm going to say a lot about that in my remarks today. But I want to start with just some reflections on enduring structural continuities. So the truth is, after spending more than a decade thinking about business fraud, it became very clear to me that the structure of marketplace deceptions has not changed very much. The tactics of deception haven't changed very much. The psychology of deceit has not changed very much. And you can see that in these two images. So the first is of irate farm family being confronted by the settler, the lightning rod settler, who has come to collect on the debts they owe as the result of their agreement to purchase a lightning rod for their home on credit. The second image is from the early 1950s, and it depicts a woman who's not very happy about arriving in a consumer electronics store to be told that the model that she had seen advertised at a great price is not available. There are a couple things I want to stress here. One is the posture of the individuals involved, whether the aggrieved consumers or the individuals who are engaged in the process of selling or collecting. Another is that both of these contexts are occurring on the frontiers of innovation, where the nature of information, the structure of information is unequal between those who are selling and those who are buying. What you see here in some respects is the continuity of the bait and switch, which is a fundamental type of fraud that has been in place for literally hundreds of years. Similarly, the basic dynamic of imposture doesn't change that much, whether one might think of it as a masquerade, as Herman Melville would have been inclined to, or as in the language of cognitive psychologists, as an example of social proof, or the representativeness heuristic. The basic dynamic with a great many frauds is predicated on social mimicry. You have to have the right props. You have to set the right scene. And here I've given you an illustration from a pamphlet put out by a mail-order investment firm in the late 1870s. And I've highlighted a few pieces. So first note that this firm claims to have been established in 1850. As compared to the building to the to the right of Baxter and Company, the New York Stock Exchange, supposedly only founded in 1864. So it's more venerable. And note that it's larger than the New York Stock Exchange. And it's located on Wall Street, which even by the 1870s was known to people all across the United States as the center of finance. Were lots of people taken in by this? Well, you don't need lots of people to be taken in by it. You need just enough if you're engaging in acts of business imposture. The most important example before I actually shift, let me make one other point here. So here's another important advantage of the long view and seeing continuity. There's some real continuity in social and cultural responses to fraud, at least in the United States. So here's an editorial cartoon from 1922. If only they could see themselves as others see them, where the sucker is looking in the window, is looking in the mirror and sees not himself, but in this rendering, the fish waiting for the hook. And of course, this individual can't see that image. What are we to make of this cartoon? On the one hand, it suggests enduring, I would argue, enduring contempt for the sucker, really should know better. And that's been an element of American policy debates about fraud since the early 19th century. But it also suggests a countervailing ambivalence. If only they could see themselves, but of course they can't, because there are many, many people who may be savvy at one moment, but as consumers or investors at another, will get taken for a ride. Okay, so lots of continuity, but the really most important advantage, I think, of the long view is seeing important turning points, moments of change. And that's really what the book centrally tries to retrace. So I'm very interested in piecing together what I refer to as regulatory ecologies. You might think of them also as policy regimes, clusters of institutions and laws and strategies of governance, norms that cohere in a given moment to set the dominant approach to any given policy issue, in this case, anti-fraud regulation. And the method in the book is to unpack that, see what that cluster of policies is like in action in a given period, and what its impact is on economic life. Then to pay attention to the critiques that emerge of the prevailing set of institutional policy responses, to trace the reforms that emerge following those critiques, and then to see a new emergence of a different kind of regulatory ecology. So the book is a tour of those over the course of a couple of centuries. Before I get into those regulatory ecologies and how they've shifted over time, I just want to offer a few preliminary thoughts about some conceptual parameters. What I'm looking at is a very large topic of business fraud. And I'm focusing particularly on what I refer to, and following many sociologists, as organizational fraud. That is, deception by a firm against its counterparties. And that would include consumer fraud, it would include investor fraud, it would also include a type of managerial fraud, termed again by legal scholars and sociologists as control fraud. And that's where the managers of a large corporation use their position to defraud both the company itself and the counterparties to the company. I'm less focused on occupational fraud, and that would be deception, deceit committed by lower-level middle managers or even lower-level personnel of a firm. And that choice partly reflected the fact that the business community is always against occupational fraud. There's an interesting story there about its extension, the extension of efforts to combat it, but it's not a particularly conflictual story. With organizational fraud, it's a very different matter, and has prompted a tremendous amount of controversy and debate over the course of the last couple hundred years. One further preliminary comment has to do with the dilemmas of defining fraud. When we use that term in our common speech, we tend not to have a legal meaning in mind. It's a ripoff. It's someone who's done us wrong and who has harmed us as the result of some act of duplicity. In legal terms, by contrast, the term has a very specific set of connotations, and I've laid those out for you here. There are a whole series of evidentiary thresholds that have to be reached in order to make a claim of fraud stick in either a civil or criminal proceeding. And the long-standing development of these notions in Anglo-American law involves not just lying, but lying about existing facts, knowing that you're lying, intending to mislead, and doing so sufficiently effectively that your counterparty is taken in and actually acts on the basis of that set of false beliefs. And moreover, that person has actually done the right kind of checking before actually taking your word for the claims that you've made. Those are potentially very high thresholds to meet. And it's very important to keep that in mind as we proceed through the talk today. All right, so the book is broken up into 4 basic periods. And these are claims that I'm making about distinct regulatory ecologies or policy regimes with respect to anti-fraud policy in the United States. I begin with a long period in the 19th century, from the early part of that century through toward the end. And the basic claim I make in this section of the book is that this era was characterized by a legal baseline of caveat emptor, let the buyer beware. Let me begin with a description of this period by P.T. Barnum, looking back on his early years working as a clerk in a rural store. Barnum commented in his autobiography in 1854, looking back at that time, that our cottons were sold for wool, our wool and cotton for silk and linen. In fact, everything was different from what was represented. The customers cheated us in their fabrics. We cheated the customers with our goods. Each party expected to be cheated, if it were possible. Our eyes and not our ears had to be our masters. We must believe little that we saw and less that we heard. So for Barnum, this is a world of complete and utter caveat emptor. Everyone is out to take advantage of everyone else. And if you're not aware of that, you are going to be shorn. So the legal gauntlets that I just described for you help to set up the world and the expectations that Barnum just described. Not simply the high legal barriers, but some practical ones as well. Particularly in the case of consumer fraud, individual harms were often quite small. And so the costs of actually going to law often were prohibitive. It also was the case that judges and juries tended to be skeptical in the 19th century United States in many fraud cases. And so it was not easy to get a fraud conviction if you brought a criminal case. Often not easy to win a civil action either. There was a policy rationale behind this set of legal norms and social expectations. A sense that this was actually the most powerful mode of preventing fraud, of providing incentives for people to have the kind of outlook that Barnum suggested that you needed to have. This would be a mode of toughening people up, of getting them ready for the hurly-burly world of the 19th century economy. It also reflected a desire on the part of legal elites to provide leeway to firms in the quickly changing American marketplace, to give them the opportunity to engage in exaggeration, puffing, as people in the 19th century would have referred to it, to provide a greasing for risk-taking, rather than having very low barriers for fraud claims, which would get in the way of new entrants who wanted to try out innovative business models. Now, I want to stress some of the impacts of this legal world on American business culture, the American business environment. One is it created really powerful incentives for businesses to engage in tactics of self-protection, as indicated by this advertisement. Look out for frauds, the Franco-American food company stresses to its hoped-for consumers. Don't be humbugged. When you buy Franco-American soup, make sure it's the real deal, because there are lots of imitators out there. It created as well, this legal environment, a strong market for new types of business services, certifications of reputation, as through credit reporting in the 19th century. In this case, by one of the earliest credit reporters, R.G. Dunn and Company, which eventually merged with Bradstreet's. It also created very strong demand for information about counterparties, about new types of businesses, new technologies. This is an advertisement from a trade journal about a different trade journal, a new one that was focusing on the emerging world of electricity. A central rationale for the existence of this new publication was to educate the public about all of the electrical frauds and humbugs out in the world. Now, I want to dwell on this point just for a second, because there are always information asymmetries in economic exchange. But by the late 19th century, those asymmetries were beginning to widen for various reasons. Partly, as in this case, because of the emergence of new technologies that were complex and that you could not expect many ordinary consumers and investors to have full understanding of. Partly because of the growth of a national economy with counterparties who lived across large expanses of space and whose reputations might not be so easy to check. And so the premise that you could keep your eyes open and use those eyes to discount what you hear, as Barnum suggested to people in 1854, increasingly struck many protagonists in the American economy and in American government and American politics as no longer quite sufficient. And those types of concerns helped to drive a set of piecemeal policy reforms from roughly the 1860s through into the 1920s. Piecemeal coalitions emerged demanding tougher action by the state in order to combat a growing perception of growing problem of fraud in specific markets. These coalitions were in every instance driven by business interests. In many cases, they found companion supporters within existing government agencies. And in every instance as well, there were crucial roles played by new types of technocrats, new experts who could survey the scene, the market that people felt was now being riddled by deception, and who had answers for specific kinds of policies that could redress the problem, that could handle this issue of decreasing confidence in specific markets because of rampant duplicity. I'm going to give you 3 examples in this second period. The first is fertilizer adulteration. Guano in the first instance. So in the mid-19th century, imported guano from Latin America became a very important fertilizer for American farmers. And just as quickly, fake guano was widely distributed across rural America. How to tell the real guano from the fake. If you weren't a chemist, the best you could do would be to throw it on your ground and wait for your harvest and then make an assumption about whether it was effective or not. And of course, there are innumerable variables that might explain the outcome aside from the quality of the fertilizer that you had purchased and used. What to do? The answer here came from a coalition of farm societies, agricultural societies at the state level, and the growing, emerging field of analytic chemistry. A group of chemists, you might think of this as a farmer-chemist alliance, came forward, either trained in Germany or trained by people trained in Germany, who offered an answer here. They could test purported guano, and then later other manures and fertilizers being created through manufacturing processes, and offer farmers evidence about whether the goods were the real thing or just adulterated. Well, you can fill in the word. This led to reforms in almost every state across the country, the creation of offices of official state chemists, and the construction of an inspection framework that varied from state to state, but in general involved inspection either at point of sale or point of distribution or point of manufacture, and the disclosure to the public of the results of the testing associated with those processes. Second example came from the United States Post Office, which in many ways was the prime mover behind this effort, although mail order businesses were quite important as well. So from the 1850s onwards, and even more importantly from the 1870s and to the end of the century, mail order emerged as a significant new form of retail distribution in the United States. And just as soon as you had mail order firms, you had fly-by-night concerns taking advantage of this new set of opportunities. The post office itself felt a tremendous amount of pressure as a result of this development, because many of those unscrupulous firms would respond to disgruntled consumers by blaming the post office. Someone would write to say, "I ordered goods from you and they haven't arrived." The response was, "Oh, well, of course. What do you expect? The post office never actually delivers." So in 1872, after a number of years of parliamentary wrangling, the United States Congress passed a new Post Office Act, and that act included a provision that created a new category of crime, mail fraud. And it also created a new mechanism for administrative action. That's what I want to focus on just for a minute here. The fraud order, which was a very powerful tool. It enabled the post office to determine that a business did not, or individual did not deserve access to the mails. And once it had made that determination, anyone who would try and mail this individual a letter would get back the letter with this type of announcement. That the individual or firm was a pack of, the individual was a scoundrel, the firm was a pack of scoundrels, all indicated with this finger pointing out and the word fraudulent on the letter cover. Final example is one that has a much broader scope, actually, which was the emergence of a wide-ranging campaign for truth in advertising in the early 20th century. Centered eventually on a network of better business bureaus, still in existence today. The key players here were the more reputable advertising agencies in the United States, as well as leading department stores and print media outlets, all of which convinced themselves that there was pervasive skepticism emerging in the consumer marketplace because of the rampant falsehoods being perpetrated in advertising. These individuals quite clearly also were worried about their own social status because, well, if you worked for an advertising agency, what kind of work did you do? And they were quite interested in trying to clean up their domain of the economy. This endeavor involved some state action, a series of false advertising statutes that were based on a model law developed by Printers, Inc., a journal in the early 20th century that lasted into the mid-20th. It also helped to shape early priorities at the Federal Trade Commission and shaped early anti-deceit work by that federal agency. But the lion's share of effort in the 19-teens and 20s occurred outside the state through this network of better business bureaus. Collectively, this group of organizations by the 1920s was much larger than the Federal Trade Commission. They were able to leverage all kinds of connections with print media to get free coverage and of their activities. They engaged in monitoring the marketplace, shaming businesses that engaged in approaches to advertising that they deemed fraudulent or deceptive, and truly massive efforts at public education aimed at both consumers and investors, as this poster suggests, trying to prevent individuals who might hold World War I bonds after World War I from converting them and chasing after some fraudulent investment scheme. All right, from the period of the 1930s through the 1970s, I argue that one sees a rather dramatic extension of what I think you could now call an American anti-fraud state. All of this is happening in the shadow of the Great Depression. All of it is occurring with much more anxiety about not just specific lack of confidence in specific markets, but rather the way that more general loss of confidence can have macroeconomic implications for the economy as a whole. It involved a tremendous amount of activity on the national level, perhaps most importantly through the creation of the Securities and Exchange Commission, but also through rejigging legal thresholds to reduce the kind of evidentiary barriers or requirements to make a case for deception in some administrative context or another. A lot of work on the part of Congress passes a series of disclosure statutes in the 1950s and 1960s about everything from the price of new automobiles, the sticker, to truth in labeling, to truth in lending. There were companion efforts across all of the states. Here's an example of one of the earliest champions of consumer protection at the state level, the Attorney General Louis Lefkowitz, who pushed a very aggressive agenda in that state. It happened at the level of cities and counties, and it was a bipartisan effort. Lefkowitz was a Republican, as were many attorneys general who pushed consumer protection agendas in this era. It also, however, increasingly balanced business interests with those of a much more powerful consumer movement. This is an image of an organization called SEPA, based in Philadelphia, which had an agenda to very much predicated on self-help to help consumers who confronted one type of marketplace scam or another to fight back, potentially through boycotts, potentially through pickets, as well as engaging with the city district attorney and the mayor to shape policy and enforcement actions. I want to stress, however, that for all of the expansion of state activity in this era, self-regulatory organizations did not disappear. In fact, they remained very important players within the regulatory ecology of the mid-20th century anti-fraud state. This is an example of a joint raid between the Attorney General's Office of Illinois and the Chicago Better Business Bureau against a notorious repair shop. This is a really great business model. So you would take someone's television to repair it, and then you would explain that it required hundreds of dollars of repairs, and then you wouldn't give the television back if they wouldn't actually pay for the repairs, claiming that you had storage costs and other kinds of costs. So this eventually led to a prosecution in 1964 with the evidence presented by the Better Business Bureau, not by the state's own investigators. So lots of cooperation, a very dense network. And I want to dwell on this point. I think people at the back of the room are not going to be able to read the details here, and that's fine. But this is one way of rendering the regulatory ecology around the regulation of the securities markets in the mid-1950s. And at the top is a very important, still relatively new federal agency, the Securities and Exchange Commission. And it's putting out all kinds of rules, and it is engaging in all kinds of surveillance, monitoring of the market. And it is engaging in all kinds of enforcement actions and lots of public education. But in between the SEC and the investor or the company were stock exchanges still, and a new organization, the National Association of Securities Dealers, created by the 1938, in the aftermath of the 1938 Maloney Act, to provide an intermediary level of regulatory oversight for brokerages, and the American Institute of Accountants, that had a very important role in setting policies and norms and standards for the accounting profession, which had crucial roles to play in producing the disclosure of information about the performance of companies, their debts, their assets, their returns, all required by the new financial architecture of the New Deal. I want to stress as well that there are other players in this regulatory ecology. The press, which in many ways was the most important regulator in the 19th century, not just the trade press, but also magazines and newspapers. They all had a very important fraud beat. They have not gone away. What has happened instead is a much more complex set of interactions and networks, and a framework that sociologists and legal scholars would tend to call co-regulation, in which you have self-regulatory organizations like stock exchanges and accountancy organizations working together with representation, with organizations of government. Let me say just a brief couple of words about the impact of this more aggressive anti-fraud state in the mid-20th century. Fraud in this era hardly disappeared. Lots of examples of consumer frauds, Ponzi schemes didn't exactly go away in the mid-20th century. Before the urban riots of the 1960s, there was really quite shocking inattention to commercial deceptions in poor neighborhoods across the country. And yet, the very worst episodes of fraud tended to happen, or tended to be perpetrated by relatively marginal firms, either fly-by-night outfits, or relatively unimportant firms in the grand scheme of things, certainly with an eye toward the overall economy. All right, let's move to the more recent period, in which I think it's fair to say we have had a fairly significant pullback from that aggressive anti-fraud state of the mid-20th century. Partly this reflected some very powerful critiques of anti-fraud regulation that emerged from the academy, from scholars, economists, political scientists in the 1960s and early 1970s, demonstrating, for example, that the Federal Trade Commission was not the most efficient player in the American government, that it also had a tendency to pay a lot more attention to relatively minor issues that created a lot of hassles for discounters rather than going after some of the more substantial deceptions in the marketplace. Partly it reflected a more general attack on excessive government emerging from the right in the 1960s and more importantly the 1970s. It increasingly, by the 1970s, found form throughout many elements of American culture. I offer this one from National Lampoon that took aim at Ralph Nader and his general concern for consumer rights. In this cartoon, I'll just, to read it for those of you at the back who might not be able to see it, this is from a Ralph Nader consumer's textbook. Beware of false magazine claims. Some unscrupulous periodicals list articles on their covers which do not appear inside. So the idea here is actually one of hearkening back, I would argue, to caveat emptor. People can look after themselves. The government doesn't need to do it for them. We don't need a nanny state. In some respects, this type of argument never went away. Conservatives were pursuing it as much in the 1940s, 50s, and 60s as in the 1970s. But the macroeconomic climate wasn't the same. By the 1970s, you had an environment of stagflation, and that set of that new context reset both politics and policy debates. And over the course of the next several decades, deregulatory premises tended to reshape anti-fraud policy, especially at the national level, but also in many states. By deregulation here, I don't mean a wholesale uprooting of agencies. The Federal Trade Commission is still with us. It still has an anti-fraud mission. I mean rather a pinning back, a pruning of enforcement budgets, a choice of leaders in many agencies who had a very different view about the priorities between facilitating growth and being concerned about consumer or investor confidence. A refusal to address new problems, a decision not to regulate derivatives at the Commodity Futures Trading Commission. To stay away from some of the concerns emerging about the mortgage market in the mid-2000s, not just at the federal level, but in several states as well. And a growing inclination throughout many different anti-fraud institutions inside and outside the government to trust more to the reputational incentives that you could count on in the marketplace. What ensued were new openings for deception, like those perpetrated by Madoff securities. Also, a really important shift, I would argue, in the scale and scope of business fraud. As compared to the mid-20th century, once again, you had really quite massive fraud scandals. In this case, by the 1980s, talking about defense industry overcharging or healthcare reimbursement fraud scandals, or into the 1990s or early 2000s with accounting scandals of that era, or the more recent mortgage debacle of that led to the financial crisis of 2007, 2008. You're now looking at costs reaching into the billions in particular fraud episodes. And I think equally important, episodes that are involving truly major corporations that have a pivotal role in the American economy. Okay, just some brief words about where we are now and some reflections on some potential implications for policymaking. One might think that the enormity of the crisis in 2008 might have reset the framework and pulled policymaking back towards a more vigorous anti-fraud stance. And in some ways, I think we can see that most powerfully through the creation of the Consumer Financial Protection Bureau, which is engaging in quite vigorous oversight of consumer finance. is developing creative new tools for disclosure to different players in the marketplace, is developing standard contracts, engaging in very tough negotiations and settlements. And yet, at the very same time that this new institution of the federal government was being created, you also had a very different kind of response from Congress in the Jobs Act, which was enacted in order to reduce the bureaucratic hassles and the costs associated with raising capital for relatively new firms. There wasn't just one response to the global financial crisis, there was a contested response. Where are we going next? Well, it's hard to say. There's a lot of tumult in Washington, as those of you who live here know better than I'm sure. But I think the signs are not likely to be consistent with the more vigorous enforcement of anti-fraud statutes. All right, so very quickly, and then I'll be very interested in your comments and questions. What are some of the broader implications for policymakers? I would argue that the 200 years of American history that I cover in this book suggests that sole reliance on market dynamics is quixotic. There are too many information asymmetries. Decision makers, and here I mean investors and consumers, all of us, are too prone to cognitive vulnerabilities. It's too easy for people to mimic the apparent reputable firms, including the gatekeepers for those firms, for us to be confident that we can rely on the market alone. We should not, that's one important conclusion. A second one is that while there are limits to self-regulatory modes of governance, we should certainly not ignore them or not think about their capacity to be part of an effective response to this problem of deception in the marketplace. They have advantages in some cases, self-regulatory organizations, not least the legitimacy they have with the business community, and the ease with which their views can be heard there. But their effectiveness depends crucially on the implicit pressure from social movements and an activist state. The Better Business Bureaus have performed best across the last century. When both of those things have been in place, they have tended to ossify when they have not been there. Third point, there simply are no magic bullets to this problem. It's really hard to tell the difference between enthusiastic puffery and intentional deceit, especially at this frontier of innovation. The evidentiary challenges associated with documenting deceit are really often complex, especially if you're talking about deeply complicated financial instruments and how people market them. And there are always going to be trade-offs when you try and curb business fraud. Doing so really vigorously is going to pinch competition. It's just going to. It's going to curb the opportunities for innovation. There's no free lunch. And a further thing we have to be aware of is that some of the most effective policy instruments, like that fraud order, raise serious questions often about due process and the rule of law. They work best when they can cut off access to the marketplace really quickly. We have a very similar program in place right now called Operation Choke Point, which I suspect very few of you have heard about, where the Department of the Treasury with the FDIC is choosing to take away the access that firms have to the online payment mechanism because they've decided that they're dodgy. But that's happening, as was the case initially with the fraud order, without notice, without hearings, and as you can imagine, it's occasioning now, as was the case then, strenuous complaints. What happened in the late 19th century and early 20th was a pattern of procedural reforms in response to those complaints that made the fraud order process more fair and also reduced its impact. The two cut against each other. The most effective anti-fraud strategies, like in so many other areas of policy, stress prevention. That means structuring the market to facilitate truthful speech through attention to norms and standards and expectations of disclosure. It means careful attention to sensible contractual defaults, like cooling off periods that emerged only in the 1960s and 1970s for consumer transactions. It means lots of investment in public education. Though here too, there's no perfect fix, because those cognitive vulnerabilities that I referenced before also mean that we turn away from information overload. And if the information doesn't come at the right time and in the right way, we are likely to ignore it or sometimes draw the wrong conclusion from it. There is as well, I would argue, a need for punitive complements, some structure for tough enforcement of the worst kinds of behavior by the worst businesses. And that is dependent on a network of eyes and ears that involve agencies that talk to each other and to non-governmental organizations, including self-regulatory organizations as well. Without that, you don't have a sense of a level playing field, and then your norms start to erode. So here, I would argue, is the perspective of the long historical view. There's always the danger of generational amnesia. There are no easy paths. Markets always harbor the seeds of corrosive deceit. But the best we're ever going to do, if we're smart and sensible, is contain this problem, and that's what we should try to do. Thank you.
All right, now hands are already up. Just a couple of ground rules. Please wait for us to call on you, then wait till the microphone reaches you. When you get the microphone, please use it and identify yourself before you ask your question. So we'll start off right over here.
And one other, don't pretend to be someone you're not.
Or we'll have to crack down on you. We'll start right over here, the gentleman with the hand up.
Thank you. I'd be curious on your...
Are?
Excuse me?
You are?
Oh, I'm sorry. I'm Joel Mulhauser.
And do we have proof of that?
I have a fraudulent driver's license, if you'd like.
Excellent.
I'd be curious about your thoughts specifically in one area of the Volkswagen fraud, and that is, it's totaled so far $21 billion. And we have very little information, the public, about how far up this went in the hierarchy, because someone at the top would likely have had enough sense, I would guess, to say the potential benefits are so much lower than the potential losses that we shouldn't do this. But somewhere, if you're in the middle there, you're not looking at the bigger picture. So therefore, I wonder if it was a middle level issue that they didn't really care about the fact that the losses might be enormous, that they were looking for the short-term gain or their own profit, i.e. getting promoted or whatever. And I wonder whether you look at it that way or have any thoughts about that. And second, unrelated, if there's time at the end, I'd be fascinated to hear what your thoughts are about class action suits, because it seems to me there's quite a conflict there of how it turned out as opposed to how it intended, but only if there's time at the end.
So you've laid out a great hypothesis for some eager graduate student to get into the records. I think that would be my strong hypothesis too, that you had incentive frameworks within the organization that led middle management to take make some of the choices that they made. On the other hand, it's also quite possible, given how difficult it was to meet the standards imposed, the environmental standards, while maintaining what Volkswagen wanted in terms of its performance. Those things were actually trade-offs. And there may well have been some more forthright direction from the top to make this go away, to find a way around it. We won't know until the evidence comes out. One of the nice things about criminal prosecutions is you get a lot of data. You get a lot of evidence, you get a lot of depositions. And one of the downsides of settlements can sometimes be that that doesn't come forward. So now I'm thinking more about what's happened with American banks in the aftermath of the mortgage debacle. There are a number of voices who have pointed out that for all of the very large numbers going into some of the settlements, it's curbing some of the investigation into the nitty-gritty of actually who said what and who directed what and how decision-making actually happened. That's a downside. I will also note that there's a long-standing phrase around the enforcement of fraud that is relevant here, the squawk fund. So that's a sort of concept of more unscrupulous firms that might even verge on con artistry, who always have a reserve fund for the really most vociferous complainers as a way to, it's just the cost of doing business. You have to have that to keep the most vigorous complainers at bay. And there's a little bit of that in some of these settlements perhaps right now. With respect to your other question, also a fantastic topic for a graduate student, and one of mine is actually working on it as we speak. So one of the things about regulatory ecologies is that, at least with respect to some issues like fraud, they abhor a vacuum. So if there isn't a capacity to address a problem in one way, smart people will start looking for others. And that's where the consumer class action, I think, and the investor class action came from, in part, particularly the consumer class action.
But it seems nowadays that the benefit goes to the lawyers. I mean, the perfect example I can think of was 30 years ago when we all got $15 vouchers for airfares. Well, we got 7 of them. And then the travel agency would charge you $6 for each voucher. So you ended up with nothing, or some of the airlines wouldn't take them unless they were up to $100. I mean, they had turned out to be worthless for the consumer.
And so there have been some perverse incentives created as a result. I will say there are some states where the attorneys general can bring class actions. And there you may see a closer alignment between the public interest and the kinds of cases brought.
You have a hand up here, a woman in the middle.
Hi, my name's Claudine Schweber. I'm at the University of Maryland University College, but I should, before I give you my question, in the interests of non-fraudulent or at least honest representation, I used to work for the Better Business Bureau here in the DC area, the council, which is the parent company. Anyway, I was interested as you looked at the key periods, whether you looked at the influence of the political, in other words, the influence of who was in power in different, whether it's at the state level or the federal level in different periods, would have, I think, influenced what kind of not only legislation, but as you pointed out, the enforcement. And I thought partly because I remember, well, not literally remembered, but I remembered about Teddy Roosevelt and the Trust Busters. Was he and his, let's say, agitation, did that in any way influence some of the anti-fraud incentives you talked about at that 19th, early 20th century time period? But how does the political, from even the ground up at the state and local and then federal level, influence some of what you've been seeing in these time periods? And should we be looking at that ground level?
So I would say that the dominance of the Republican Party in the early decades of the 20th century, aside from the Wilson administration, was a crucial backdrop to the dynamic that ensued. This is particularly true in the 20s, right? So you've got Herbert Hoover basically said charting a framework of policy which was not about I would argue, a weak state. It was about a state that wanted to operate in very close partnership with business-related institutions to solve certain kinds of problems in a way that would be optimal from the perspective of the business community. Every president, from the inception of the Better Business Bureaus onward, sang their praises, the Republicans particularly so. And the idea was in part that this mode of self-regulation would largely solve the problem. So even the Federal Trade Commission shifts very significantly during the 1920s in its orientation, with a focus particularly on industry-wide formulations of rules of fair competition. So it's not that the state is somehow gone, it's just oriented in a particular way that absolutely reflects the governing philosophy of parties. And that's true. I mean, I could give you other examples. That's right.
And who's elected locally and congressionally?
Yes.
Thank you.
Over there, yeah.
Thank you. My name is Karl-Henrik Geschwind. I'm just wondering whether you have any ideas on comparative perspectives. That is, in the story that you're telling, it's the New Deal and the neoliberal efforts of the 1970s that are the big turning points. Is the story the same or different in other countries such as Great Britain, which did not have a New Deal, or Canada, which had neither a New Deal nor a neoliberal backlash?
So there are some parallels. The story in Great Britain in the 19th century is very similar to the one in the United States. So relatively light touch in many different regulatory contexts, whether that's administrative or the framework of civil actions or the framework of criminal actions, as to the United States. So it's also very much a domain of caveat emptor. That starts to shift gradually in the late 19th century in specific markets in response to particular concerns. And there are a number of important aspects of what become the New Deal securities framework, which borrow actually from the British example. It is certainly the case that something like fertilizer regulation is basically a European import. You know, this is emerging. The carriers of that set of proposals are these chemists who've encountered the approaches that had become commonplace by 1865, 1870 in German principalities. So that's very much a transatlantic crossing. There are other dimensions of the story that are much more uniquely American. The mail fraud approach. This is something that is not, I have seen no evidence that this is a borrowing at all. And then of course, by the time you begin to hit the mid-20th century with the shifts in geopolitics, it tends to, you know, I would argue that as best I can tell, there seems to be a little bit more of influence going in the other direction from the United States to other countries. But I would say this is another great area. We need a lot more research on this. There is much to be learned. So those are sort of my initial sense.
Right here, Stephen.
Stephen, your wonderful talk. I have two brief questions. The first is, any correlation between business fraud and campaign contributions? Because it seems to me that those who are committing fraud have greater access than those who are victimized by it, and the almost universal extension of compulsory arbitration clauses in more and more business contracts.
So I'll start with the first. It's really hard to convict powerful, well-connected people of fraud. And that's often true because they are pillars of the local community. So fraud also often has a geographic dimension, especially investment fraud. If you're sitting in a Colorado mining town in the 1870s or 80s and you're trying to bring capital in, the local population doesn't really mind if you play a little fast and loose with the truth, if what you're doing is bringing in capital. And then if there are outsiders who feel they have been ill done by, and you end up facing trial in that place with the jury made up of those people, it's not straightforward. E.G. Lewis in the early 20th century was probably the most celebrated businessman who found himself facing mail fraud allegations. This guy was based in St. Louis, University City, outside St. Louis, if anybody knows it. He built that. So he created, for a time, the largest periodical in the United States that targeted farm women. He got in the business of mail order banking, so that he had an early distance banking operation. Lots of interesting things about his business holdings, and lots of really dodgy business practices. He understood the value of political connections, so he gave a lot of funds to a lot of people in Congress. He had a very close relationship with a number of those individuals, and he leveraged it for all it was worth. In his case, it wasn't enough, and I can make an argument in the book about why that was so. But many, many prominent dodgy businessmen in the early 20th century understood the value of being able to put a member of the House of Representatives or a couple of senators in your pocket, and they tried.
Compulsory arbitration.
Compulsory arbitration. So this is another example coming partly from states, but also from the United States Supreme Court of the contingent nature of the response to the slap in the face we all got in 2007, 2008. The ruling, I think the Concepcion case you may be thinking of, is one that is making it much easier for firms to require compulsory arbitration. And that is a constraint on the capacity of consumers to vindicate any claims they may have for ill treatment. So it's stacking the basic marketplace in a way that arguably offers greater ambit for deceptive practices or other types of abusive practices. That will not be shifted without different people on the court or a different impulse on the part of the United States Congress.
In the far back, gentleman straight back there.
Or far back? Okay. Hi, Greg Klass from Georgetown Law. I have two questions, one from the beginning and one from the end of your story. From the beginning, I wonder if, I'm sorry, I haven't read the book yet, if part of the story, if the False Claims Act figures at all into your story. That was 1863, one of the very, very early fraud statutes. I wonder whether that connects up, or is that sui generis? Does that connects up with the movement, or if it's sui generis? The second is maybe as much of a comment about 2008 and the mortgage crisis. I was thinking while you were talking about it, about the Second Circuit Court of Appeals decision in the Countrywide case last May, where it was Fannie Mae and Freddie Mac suing Countrywide for bundling all these crappy mortgages and so on. And the Second Circuit said, they overturned the trial court and they said, we just can't find any deception here. There was a warranty at the beginning, but that wasn't false then. And then once the mortgages were being delivered, Countrywide never, well, Fannie Mae and Freddie Mac never asked, and Countrywide never told, right? And so that's just, it's about, I guess the question is about bubbles aren't always deceptive, they aren't always fraudulent, sometimes everybody wants to believe. On the other hand, maybe it's just reaffirming your point that what counts as the morals of the marketplace is going to be what defines what's deception and what's not, or what's fraud and what's not.
So on the first question, I do talk about that Civil War era False Claims Act in the chapter on the emergence of these piecemeal coalitions for dealing with specific problems. And I come back to it actually in the last chapter as well, because there's an update of that False Claims Act in the 1980s. And it's an example of one of the countercurrents against the deregulatory, the dominant deregulatory trends. So the overcharging in the defense industry gets a response, and the response actually is quite powerful, but it's also reflective of the dominant political party at the time, right? So the Republicans are governing that process, particularly in the Senate, and Charles Grassley, a Republican senator from Iowa, prefers to leverage market incentives through an update of the False Claims Act as a way to really deal with government overcharging government reimbursement programs than some type of heavy-handed administrative approach. On the second point, I think you're absolutely right. I suspect, although I haven't read that particular opinion closely, that there probably was a lot made of how sophisticated the people at Fannie and Freddie were, that they should have known their business. And so I think that's part of that's likely to be part of the equation here as well. And there is absolutely a dynamic where what's a bubble at one moment looks like intentional deceit after the house of cards comes tumbling down. It's also the case that there's a different dynamic that can be at work, so that once things start to go south, people in firms start making decisions in the hopes of forestalling that, which can move you closer towards intentional deceit in some cases. But these are complex, very complex questions if you're trying to assess right or wrong, or liability or not liability in specific instances, for sure.
Ed, I want to slip in a question here, if I may. You note throughout the book that wherever there is any efforts to curb fraud on the part of the government, there is a countercurrent of those who resent those efforts, either because it affects them personally, or especially because it affects them personally. When you fast forward to the 1970s, something changes, and that countercurrent is supersized. And you note that there are academics and legal scholars and others who kind of generate a body of literature that is critical on about these sorts of regulations as retarding economic growth and or curtailing individual liberty. But business, too, picks up on this. And this is a shift from the wonderful chapter on the Better Business Bureau and corporate America's efforts to police itself. And so going forward into the 80s to the present, it's almost as if, as we look at WorldCom or Enron or the mortgage crisis and the meltdown of 08 onward, that business is no longer concerned with its own reputation, and it's willing to trash all regulation, or much of it affects them, because, I don't know, the gains are just so obscenely large that they will take any reputational hit. But that impulse for corporate America to police itself, it's concerned about its own reputation. It matters that their name is good. That doesn't feel like it's so much in play anymore. So could you talk about that shift?
So I think that one prefatory comment, and then I'll shift gears a little bit. So the prefatory comment is we have to be aware of monolithic treatments of business. All corporations are not alike, and all people who work in even unscrupulous corporations are not alike. We need to be careful about essentializing the business community. That said, I do think that very important transformations occurred in the 70s and 80s, and there are a number of different places one can look for those. There's a background condition, which I think is generational amnesia. So the business elite of the 50s and 60s, 40s, 50s, 60s, had lived through the Great Depression. And they had also lived through the Second World War. And they had come to an accommodation with the state. They worked with a newly gargantuanly powerful American state in not always the easiest of fashions, but reasonably cooperatively, and with other players at the table too, big agriculture and big labor. In the aftermath of the Vietnam War and the difficult economic conditions of the 1970s, there was a moving off the stage, I think, of many individuals who had that deeper set of experiences that shaped their outlook. And you also had, and here I think the power of ideas really matters, you had an instantiation of these academic critiques that you referenced from people like Richard Posner from the Legal Academy, from Milton Friedman, from a number of very powerful economic thinkers on the right, an instantiation of their approach to things into the core of law schools and business schools. So the generation of leaders that took the helm not so much in the 70s, but certainly by the 80s and 90s, is reflecting a world of assumptions about short-term, the value of short-term incentives, that's reinforcing a set of norms about get it now while you can. IBG, YBG, have you ever heard of that? I'll be gone, you'll be gone. And, get yours. And that's not to say that that culture is, permeates every decision and every bit of organizational culture in every large corporation in the United States, because it doesn't. But it had, I think, growing salience in the firms that ended up behaving in the worst ways that led to the worst fraud episodes.
Gentleman right here, the hand up, gray sweater.
Hello, Richard Willing. Thank you for coming to work today, Professor. As a New Yorker, I can't help but note that the two guys, obviously with false names, arrayed on your right, look like you're ready to launch a three-card Monte game. I just wondered if, whatever became or what has become of the fraud order and that wonderful J'accuse stamp that was used?
So it has not, I don't think it's as strong a part of the arsenal of the federal government now as it was.
It's extant.
Sorry?
It's extant. It's still.
I believe it is still extant, yes. It has transmuted in a way to this effort against internet firms that depend on the online payment mechanism, one could argue. It, in some respects, was a casualty of two things. So one, the legal procedural reforms that slowly made the order less valuable. So that was a chipping away at its impact. There also was a recognition that, like every other anti-fraud tool, it too has limits. So if for the worst fly-by-night firms, you can put a fraud order on them and they'll just reopen 5 minutes later with a different name or a different address. But also another key element was around mid-century, courts became a little more, after actually being quite willing to delegate authority to the post office, they became less so from mid-century onwards, in part because there were now all these other tools. The Federal Trade Commission had much more substantial authority. There was cease and desist orders that you could get through the Federal Trade Commission. And so there was a growing disinclination on the part of the federal courts to sort of give the post office a lot of leeway. I will say that actually that mail fraud criminal prosecutions became more substantially significant at that same point in the mid-20th century. And I think it's still fair to say that the Postal Inspectorate has quite a high reputation for its capacity to engage in not only complex investigations, but to actually deliver prosecutions.
Ross? And then
Ross Johnson, Wilson Center. Where does wire fraud fit into this? And I mean, in two respects, how did it get into the law? And, at least in much of the popular.
So wire fraud comes in with the telegraph and then other forms of communication. And it's an extension of mail fraud. I'm going to have to actually check as to the year that Congress extends that. But the basic structure of the law is quite similar. The focus of it, though, is very much on criminal prosecution, as you suggest, in part because the post office, the government itself, was not providing unlike in so many other countries across the world in the early 20th century, late 19th to early 20th century, was not itself providing telegraphic services. But you're right, that tool of addressing difficult kinds of prosecutorial contexts is an important element of that piece of the law.
All the way in the back, and then gentleman in the back there, and then.
Tom Timberg, consultant. First, of course, I want to thank you for a book which I'm now going to read. It strikes me we have a North Carolina school of understanding the historic process of development of regulation, because I think of a very similar book out of UNC on the antitrust laws and how they have developed. But I'm wondering if you haven't talked at all about what I would have seen as a dialectical process where we lighten up on regulation, we have scandal, then as a result of the scandals we impose regulation. The way this is being expressed in Washington is some confidence that if our new president manages to lighten up on regulation, the result will be scandals, and as everybody says, a lot of employment for lawyers. To what extent is, besides the progressive, if you will, periodization that we have, do we have this sort of cyclical process?
So no, I think you're absolutely right about that. The political scientists would refer to the scandal as a focusing event. And there is a dynamic there where in many cases, particularly once you get into the 20th century and people are thinking about the macroeconomic implications of lost confidence, events that achieve real prominence in the press have a tendency to especially if they all fit the same kind of meta-narrative, can reshape the conversation about where policy needs to go. And sometimes the story that matters is as much the minor story as against the major one. So the fraud story that maybe had the most impact in the 1930s, I don't think, it wasn't actually about law formation, it was about accommodation to the reforms of the 1930s. So I don't think it was the mail fraud case against Samuel Insull, who had this massive utility conglomerate in the Midwest. I don't think it was the death of Ivor Kruger in Paris. It was a really garden variety fraud committed by Richard Whitney, who had been the president of the New York Stock Exchange and was the voice of the establishment in fighting the New Deal. And that fight did not end after 33 and 34. The investment banks were not really wanting to play ball with the Securities and Exchange Commission for several years thereafter. It was only when Whitney was found to have embezzled from the New York Yacht Club and another organization that he had a fiduciary responsibility for, to the loss of widows. It was only at that point that the organized resistance to a different frame for financial regulation crumbled, and basically the flow of capital started moving again with the disclosure premises of the New Deal. I think the point I made, I didn't use the word dialectic and I didn't use the word cyclical, but I did use the phrase generational amnesia. And I think that really gets at what you're talking about. We solve problems, and then we forget about why we solved them in the ways we solved them. But we also confront new problems, and those new problems matter more to us. And so we often may we may miss a few steps in trying to solve the new problems because, well, our historical perspective isn't what it might be.
Thank you. We're quickly running out of time. Let's take a last round of several questions and then give you a chance to respond to them, probably not all of them. We'll start here and work our way around the table. So, gentleman up front here, and then hold on, the microphone's coming.
Thank you. David Sobelson from Washington, D.C. The two different titles of your talk, Professor, suggest a question to me. Your talk actually has two different titles. One is Fraud in American History from Barnum to Madoff, and the other is Business Fraud in America from Barnum to Madoff and beyond. and the use of the word business suggests to me that what we're talking about is human psychology and human behavior that doesn't occur just in business. And I'm wondering if there's room for a study of fraud in politics, and whether there are candidates in different times in American history who've used the same tactics that business scammers have used in order to obtain political power.
Thank you. The gentleman against the wall there.
Thank you. Joshua Kaufman. As I'm listening to this, and it's a historical talk, of course, does any of it have relevance to the future? We're not having the centralized frauds of the companies today. The greatest fraud we're seeing is from international, the scammers, the internet. I mean, yes, this last week, a guy in Turkey had crews around the country, $81 million they took out in 3 days from ATMs. I mean, you have this massive fraud, but it's all decentralized. It's all, there's what regulations, what any of the things that you were looking at has any bearing on the frauds of the future?
Thank you. Over here, Miranda, right here.
Thank you, Dave Rabinowitz. You mentioned how history should help determine policy. I'm wondering if you came across any good ways to treat convicted fraudulent people to try to reduce the likelihood of recidivism. Because fraud is the kind of thing that's going to be repeated as long as someone can get away with it.
Thank you. Any other questions? Okay, then that's it.
So these are a great set of questions to end with. On the first, fraud in politics, I think there is enormous scope for all kinds of historical research and research from other social science disciplines as well about this. I will make just one quick comment. So one of the most sophisticated techniques of deception in the marketplace is to build a reputation as a finger pointer. So by the early 20th century, fraud in the investment markets was sufficiently sophisticated that there were people pushing it through financial newsletters that would tell you about all the frauds in the marketplace, and they would build up a reputation for 12, 18 months, and then they would tell you about this great mining operation in Idaho. George Graham Rice was a master of that. You see that perhaps going on in politics right now. I think there's tremendous scope for that, and I would stress the importance of looking not just at the development of electoral commissions or the questions about actual voter fraud in urban America in 1883, but rather I think what we might best learn from would be really careful analyses of the norms about how far you can push it and what happens if you go beyond complete and utter prevarication about the nature of our political life. I think we've had an underappreciated history of such informal structures. One might think of this as a sort of informal constitution that helped to structure American politics. I don't know that we have actually had people asking the questions that would be necessary to uncover that history. It's a history we need to uncover, I think, quite badly right now. Relevance for the future, absolutely right. International, in fact, I think the one dynamic that I should have said something about in the last chapter, which I did not, is the emergence of tax havens, which has facilitated quite a lot of international fraudulent activity over the past 30 to 40 years. That said, I think the story in the book has enormous relevance for it. Not just because once you have an SEC, a lot of boiler rooms move to Toronto, but because a lot of the move towards a more vigorous federal response in the late 19th and early 20th century was a result of the divided jurisdictions of the states. And so if you're operating across state lines, what can an individual state do? Their capacity to extradite, to investigate is really very limited. So where that moved was a shifting of of sovereignty and jurisdictional power. What does that mean in an international context? It's going to be much more complicated, but I think there are indications of what you need. And one example is what is already happening, which is a much deeper set of networks and an integration of policy discussion and enforcement cooperation across international boundaries. On the question of recidivism, I honestly don't know what to say about that, other than there are almost certainly enduring psychological patterns and tendencies and personality types that correlate with the inclination or willingness to engage in deception. But I suspect the psychologists may be more helpful on that than the historians.
So on that note, we draw this to a close. Let me remind you that we do not have a seminar next week on President's Day, but on February 27th, join us for Timothy Breen of Northwestern University talking on his new book, Project, An Appeal to Heaven. We have a reception outside this door right now. Fraud is available for purchase, the real thing, not a knockoff, and this really is the author, so you can trust us on that. Thank you to our seminar participants. Thank you to Ed Balleisen.